Good morning, everyone. Thank you all for joining us today. For those of you who don't know us, my name is Sandra Perez.
And my name is Yomara Andrade.
And we're account managers for PRC Restoration, and we're your hosts for today. Before I welcome our guests, I want to briefly introduce PRC and what we do. PRC has been in business since 1988, providing emergency assistance throughout Southern California for properties who have been affected by water damage, fires, mold, sewage, or any type of property disaster. Currently, even COVID with our disinfecting service. We are a 24-hour full service restoration company, providing service from the initial mitigation to the build back, both for commercial and residential properties. We're always on call and respond within an hour to any property emergency. So I will leave our contact information on the chat. So if you guys want to contact us for any information or if you have any questions on our services. And now for who we're here for, I want to introduce Patty. Patty Widget has over 25 years of experience as a regional property manager, and she's here today to update us on the new housing laws. Welcome, Patty.
Hi. How's everybody doing today? Do you guys still do free estimates? Oh, we can't hear you. Did you mute yourself? Can you guys hear me? Okay.
We can hear you. Sandra,
okay.
Can you unmute yourself?
Sorry about that. It wasn't letting me unmute. The button was stuck. But yes, we do provide free estimates. So I do recommend that you guys take advantage of that.
Yes, keep them in your arsenal, you guys. It's a great tool to have in your arsenal of property management tools. Having a free estimate sometimes makes everything happen that much faster for you, especially when you're dealing with insurance companies and you're trying to keep that landlord-tenant balance right. The quicker you can get somebody out there to address a tenant's problem, usually makes everything else flow nicely thereafter because it makes them feel like you care what's happening to them. So very important that you jump on those things right away. Thank you, you guys, for doing that for your clients. It goes above and beyond. And just so you guys know, I have actually used PRC Restoration Company myself. And I've recommended them to a lot of people just because they're spot on, not only with the information that they give you, but the way that they treat your tenant when they're out at the property. Very, very important, especially in uncertain times when you're dealing with a fire or mold or something that causes a lot of anxiety anyway. And their staff is trained to the T to help sugarcoat that, make things easy, and they're highly on my book of business for you guys. I will automatically say, go to PRC, call PRC. It's just, they're spot on with the services that they offer.
Thank you for that, Patty.
No worries. I'm being honest. All right. Are we ready to get started today? I'm sure everybody is so sick of hearing about COVID, but I will tell you this. With the new Senate Bill 91 that was implemented on January 28th of this year, I see light at the end of the tunnel. Okay, so hear me out, you guys, and then we'll get started on what's going on. There are some things you need to pay attention to that are detrimental to making your business successfully function. So please pay attention. I may ask questions later. Number one, most important thing is in the new Senate bill, I see not one, but 2 pages of retaliatory issues. What does that tell me? It tells me they're starting to tell us how they're going to punish us if we break the rules. So that tells me that they're probably going to release some of these restrictions. I think the state's going to open at the end of June when this particular Senate bill is done being processed. We're starting to see some businesses reopen. If anything gets extended in my brain, I would think that it would be LA County that would just extend a moratorium and everybody else would be free by July 1st. Cross your fingers. Let's all hope that's what happens. But that's what the way the law is going, that's what it's leading me to believe. So with that being said, let's get started with what you need to do on or before the 28th of this month. For those of you that aren't paying attention, that's 3 days away. You got 3 days, guys, 3 days. So you must notify all of your delinquent tenants of the new state COVID Tenant Protection Act on or before February the 28th. That's in 3 days. You can physically post the notice on their door on the 28th. There's not a problem with that, but it has to be done on or before the 28th. What will happen if you don't do this? You will not be able to evict for non-payment going forward. And it will also make it so that you can't apply for the government bailout funds. This is not a loan, you guys. So pay attention when we get to that part too. Also very, very important. So don't forget, on or before the 28th of this month. Where can you get that disclosure? I get this question a lot. Your apartment association should have the disclosure for you. And you can also contact your legal counsel. They'll do it for you. I know that Fast Eviction Service is doing this notice by itself for you for $125 if you mention Widget and Widget's Way. That's me, just so you know. So very important that you do that. If you don't want to serve it to tenants that aren't delinquent, you don't necessarily have to, but that is going to hinder you from being able to evict for non-payment going forward for March, April, May, and June. So the next 4 months, it could hinder you from doing an eviction for non-payment of rent during that time period. So that was the important one. If anybody has any questions about that, I can answer those at the end, but let's go ahead and move to the next slide, Hootie. Eligibility for rental assistance. Okay, just so you guys understand, the new bailout program, and the reason I'm calling it a bailout program is it's not a loan. Okay, very, very important that you understand it's not a loan. This is money being offered by the federal government, and it's being administered through the state of California. Please hear me, okay? Read between the lines, take it for what you want. They're not helping nail salons. They're not helping restaurants. They're not, and I mean they as in the government, okay? They're not helping restaurants. They're not helping nail salons. They're not helping these small businesses. Why are they helping landlords? Because if they don't do something within the next 6 months, half of the state of California is going to be homeless, okay? Half of the state. So that's why the government is opting into this program. That's why they're trying to help tenants and landlords, is because they don't want us to evict them, okay? So very, very important that we understand how that all works. The landlord can apply for that money on the 15th of March on a website called housingiskey.com. I would strongly recommend that you set your alarm and get up at 5 a.m. to do that, because it's a federally funded program. It should run on New York time, not California time. So once the money's gone, the money's gone. So you want to make sure you're in line to apply. If you, the landlord, choose not to apply for this program and get into these government funds that they're distributing to help stop homelessness, please take note that your tenant can then apply to get the 25% of the rent so that you can't evict them. So that's how that works, is the landlord can apply for the 80%. They have to forgive the 20%. If you opt out of the program, then the tenant can apply and take the 25% for the next 4 months so that you can't evict them for the next 4 months, just so that you understand. Do it at 5 o'clock. I can't encourage you enough, because once that money's gone, it's gone. Don't think that there's going to be a big outpouring from corporate America and our major property management companies, because for the most part, they're having their rents paid. I want to say in corporate America, they're less than 10% of delinquency. So this money really is geared towards the independent rental owner. It really is geared towards helping you avoid foreclosure. So definitely something you want to take into consideration. There is going to be something in the fine print saying if you take this money, you can't evict your tenant for non-payment for such a long period of time. It could be 6 months. It could be 12 months. We don't know yet. We won't know until the program is released on the 15th of March. I can tell you this. have your tax bill ready. And this is just the way my little blonde brain works. But if we pay the government our property taxes every year based on our APN number, not on our property address, and now we want the federal government to pay us, don't you think we need to speak their language? Don't you think we're going to need to have that APN number handy, since that's how they identify us? It makes sense to me. I don't know that you'll need it, but I'd rather have you have your tax bill handy in case you need your APN number than need it and not have it. Make sense? So make sure you have your tax bill ready. Make sure you set your alarm for 5 o'clock in the morning because it will most definitely, like I said, once the money's gone, it's gone. Okay, next slide. When the state will begin accepting applications for the rental assistance. That's going to be on the 15th of March. And I strongly urge you to get up and do it sooner rather than later. I believe it's $2.6 billion they have for landlords, and really want to make sure that you guys are getting that. The amount of past due rental debt that can be paid by rental assistance funds is 80%. If you participate in the program, you get 80% of the rents that are due on your ledger. So even if your tenants made that 25% payment, you're going to get 80% of the balance on your ledger for each month that COVID was in place. You have to forgive the other 20%. And a lot of people tell me, Patty, why would I participate in this and give away 20% of my money? Ask your local restaurant what they're having to give away. 20% is peanuts considering the rest of our state, let alone the rest of the nation. Okay. So please keep that in mind. They're not helping other people. They're helping landlords. And it's so that we don't have a homeless problem. Well, I should rephrase that. So that we don't have a worse homeless problem. Because we already have one. I know. All right. Next slide. Is participating in the state rental program assistance program mandatory? No, an owner can say that they don't want to participate, but then if the owner opts out of the program, the tenant can apply on their own and get that 25% so that you can't evict them. Just a key note here when applying for this money, please don't think that if you apply on March 15th, you're going to get the money on March 15th. We're dealing with the government here, folks. Chances are it is going to take a bit to get paid. My guess that would be that funds wouldn't be administered until June. Just saying. So definitely something to think about. It's not going to happen quickly. It's the government. Just saying. Okay. They don't do anything quickly unless they're fining you, right? So I don't think that money is going to be available to you as quick as we all really want it to be available to us, but it still will be available. Next slide. "15-day notice extension, 25% of the rent." So currently, Senate Bill 91 is what currently controls us, SB 91. You guys, it's 47 pages long. It's insane, okay? All the rules, the regulations, how everything's gonna come into play. Because there's more defining of how this is gonna go, it makes me think, again, that it's not gonna be extended for another go around. So if the tenant, you have to serve a 15-day notice, and this started back in September of this year. So all the way through June, non-payment of rent is a 15-day notice. You also have to give the tenant a declaration that they would sign and return to you, stating that they were affected by COVID. And you also have to notify them of their rights under the new Senate bill. So there's 3 documents that needs to be served to a tenant. My opinion at this point is if this goes and it closes and nothing else is extended, we'll be back to using a 3-day notice to pay rent or quit on July 1st, July 2nd. You can't serve on the 1st. That's when it's due. It's not delinquent until the 2nd. So I have a good feeling we'll be back to our regular 3-day notice to pay rent or quit starting on July 2nd. Yay! I know some of us have been waiting for that. This 15-day notice is just ludicrous. It's 15 business days, not 15 calendar days, okay? So just keep that in mind. It ends up being about 20 to 24 days, depending on the weekends and how they fall and how those are served. So it can become a little bit tricky. I'm going to stop right now and see if we can answer some questions. Hootie, do we have a few questions I can answer before we go to the next slide?
Sure.
Did I answer them all?
One sec.
No worries. It's okay. Everybody knows I'm a little weird. I do things strangely, but hey, I get my point across.
We have a question. When are we allowed to raise rent?
Don't pass go. Don't collect $200. I'm going to talk about that with you guys. If you have increased rent at all during the pandemic, okay, at all during the pandemic, and your tenant has been delinquent, that is now considered retaliation. There are fines and penalties in there, up to $2,500 per occurrence. In my blonde brain, per occurrence would be for every month that increase took effect. So do yourself a favor, reverse any increases that were done during the pandemic, give them a credit on their letter immediately, a credit on their ledger immediately, and then notify them. Hey, with the ever-changing laws, I want to make sure that I'm following all the rules. So we're crediting back the rent increase that you were given on such and such a date. Please know that there's a credit on your ledger towards your next month's rent, or however you want to word that. I wouldn't give them money back out of your pocket. That's a bad business practice. Just give them a credit on their ledger going forward. But wouldn't raise the rent anytime soon. I want to say check back with me in July, on July 2nd, and I can give you an update. But most likely you're not going to be able to increase rents until January 1st of 2022. And that would be you playing it completely safe, waiting a full 180 days after the pandemic has been dispersed and giving them 6 months to recuperate before you did any increase. So that would be the best business practice, is not to increase rents until January 1. Number 2, if your tenant has not been late throughout the entire pandemic, technically you could do a rent increase during the pandemic and not be considered retaliation, but you're subjecting yourself to litigation, which is very expensive. So in order for you to prove that you're right, how much money are you going to spend with legal counsel? And is that going to cover the increase you did? Probably not. So it's better ethically to not increase the rent. It's a bad business practice. Think about it like this, okay? What if your mortgage company said, we're raising your mortgage, but you cannot raise the rent on the tenant? If you increase the rent during the pandemic, that's kind of what you did. We're told them they have to shelter in place. And then we turned around and raised their rent, but they can't move out. That's not fair. It's not right. Just because something is legal doesn't mean that it's right. There are a very small amount of people that are truly affected by the pandemic. I believe the numbers are 15 to 10% of the delinquency. Those people really need help. You guys, I understand that we're the victim here, but those people really do need help. I'm gonna share a little story with you, and then we'll move on to the next slide and go forward from there. But let me just say this. At the law firm, I had a gentleman call and he said, I need to do an eviction. My tenants didn't pay February's rent and they're not going to pay rent going forward. I already know. And I said, well, why? What happened? He said, well, the mom died of COVID in January, and in February, the dad died of COVID. So I'm not going to get my rent. I need these people out of my house. I said, okay, who's left behind? A 17-year-old child, a 14-year-old child, and a 7-year-old child. Those are victims of COVID-19. Those are the people we need to be helping. It's not their fault they lost both their parents and they're now having to deal with this. If a family member doesn't step up and take care of them, they're going to get awarded to the state and get put in the system of foster care for the rest of their lives. That's a problem. Those are the people we need to help. We need to understand that we may not all be in the same boat because some of us are on a life raft, some of us are in a kayak, and some of us are in a yacht, but we're all in the same storm. We're all being affected by the same storm. It's just the manner of which we are floating currently isn't the same. Some of us are in a much worse position than others, and we need to just remember that people really truly have been affected by this. Not everybody is just exercising their rights and trying to take advantage of the system. Okay, please keep that in mind. There are truly, genuinely people that have been affected by this, and it sucks. Okay, I mean, look at us, look at those kids. They just lost both their parents. Yeah. Yeah, I got no words for that. Okay, I get it. I understand. And then we have the other people that are taking advantage, and that makes us angry and makes us frustrated. I get it. I know. Again, same storm, different boats. Okay, everybody's in a different boat. Okay, next slide. It would help if I had my right glasses on. Statutes of no fault evictions and tenant at fault evictions related to non-payment. They added a lot of protections in the new bill and a lot of retaliatory issues. So let me say this, if you're currently in an eviction matter, okay, and you are evicting for cause, meaning you want to move back into your property, have a family member that wants to move back into your property, okay, that would be no fault eviction. And then we have the cause evictions where they're breaking the rules of their rental agreement. They are destroying the property inside and all of this. If they have ever been delinquent on the rent throughout the pandemic and now you're evicting because of cause, that's most likely considered retaliatory, and your legal counsel needs to know, because you're going to want to dismiss that case before it goes any further, to avoid fines implemented by the court for retaliation that start at anywhere from $500 to $2,500 per day or per occurrence. So we just want to make sure that if we are currently in an eviction matter, that we don't have any issues of retaliatory coming about. None of us want to get fined for money that we don't have because the tenant's not paying us. So we need to be very, very careful that we're not setting ourselves up for failure. No fault and fault evictions, two totally different things. No fault would be owner wants to move back in, has a family member that wants to move back in, something along those lines, versus fault being either non-payment or destruction of property, modifications to the property without written consent of the landlord, material breaches of the lease contract, things like that. Those would be fault versus no fault. No fault meaning the owner wants to move back in, a family member wants to move back in, something along those lines. Next slide, please. New prohibition on the late fees and increasing other charges. Okay, let's go back to the money, you guys, because this is very, very important. Throughout the pandemic, starting in March of 2020, you absolutely, positively cannot charge a late fee on a residential dwelling. Period. End of report. If you do, that is retaliatory. So we need to go back and credit any late fees that have been administered on the ledger or that tenants have paid already, and reverse those immediately before we get our butts handed to us in court. Okay. So we want to make sure we're reversing any late fees or any increasing charges. Nothing can change for the monetary amounts, meaning the money from the tenant of what they were being charged from March of 2020 through June of 2021. No rent increases, no additional expenses, no late fees, no NSF check charges, no other additional charges to them at all, or it's considered retaliatory. Okay? Be very, very careful that you're addressing your ledgers and making those changes before we get 5 years down the road and we can't remember what happened. It's more important to do it right now while it's all fresh in your memory. Okay? Also, for those of you that are following the ledger process, because the government wants us to keep no more rolling ledgers during COVID. They want us to keep actual ledgers. So they want us to say, in March, the rent was $1,000, but they gave us $3,000. They want that documented month by month. Don't go back and change all of your accounting software from Appfolio to reverse all this stuff and make this all work in order to go through court. If you are in a legal matter, just make yourself a column or ledger. Do it with pen and paper. It's much easier. We're talking about 16 months versus your whole accounting program. So if you need to go to court or trial or provide a ledger to somebody, keep a column or ledger. It's super simple. It's easy. It's on a piece of paper, and then you're not having to adjust all your programming. But do make sure that you remove any late fees or any additional charges to the tenant. I saw something come through, charging things back to a tenant. They can have no increases in charges from the time COVID broke out through the time COVID goes away. So from March of 2020 through June of 2021, if you have something where it's tenant caused damage, like they broke a window, I'm going to use that as an example because it happens a lot. I wouldn't put that on their ledger. I would take that out of their deposit when they vacate. They still owe the money, but we don't want to include that in the COVID period and have that be a problem or have that come back and bite. Okay. We can go to the next slide, Hootie. New protections for landlords who had to close amenities. Yes. Okay. So for those of us that had to close a pool or a clubhouse because of the amount of people that could congregate together or things of that nature, if we had to close amenities, there's no rent credit that needs to be given to the tenant. That was beyond our control. It was due to a government order. So if you have a tenant that says, hey, you still want all my rent, but I can't use the swimming pool or the gym, are you going to give me a credit? We don't have to give you a credit. We won one. Okay, you guys, we won one. Everybody take note of that. So we want to make sure that we're not giving them credits where we don't need to, because quite frankly, we're on the losing end of this. Okay, just saying. Next slide. New restrictions using information about COVID-19. Okay, this one is very, very important. And then I'll take questions again. Okay, so if you guys have them, type them in the bottom so Hootie can give them to me. But this one's very, very important. I want you to start thinking of COVID-19 as a bubble, okay? From March of 2020 to June of 2021. And remember, that could be extended, but I don't think so. Anyway, that is a bubble. You cannot talk to other landlords about their rental history during COVID. They are protected. And here's an easy thing that I came up with. If they're affected, they're protected. So keep your mouth shut. You can't talk to someone inquiring about their payment history during COVID. Okay, that is discriminatory. That is retaliatory. There are fines, fees, and penalties that come with that. So if someone is inquiring with you on what happened with the tenant, zip your lips. Okay, you don't want the lawsuit. You don't want the fines. We got to save money, not spend it, you guys. So although they may not have paid us through the entire pandemic and we had to apply for the 80% from the government, we can't tell that to someone that's inquiring about them as a tenant. So you can use words like, I'm sorry, I don't disclose anything that happened during the pandemic as it affects the entire planet. Okay, but don't tell them they didn't pay their rent, they were late the whole time, they this, they that. Do not talk about anything that happened in that COVID time period bubble. Okay, you can't. They are protected. If they were affected, they're protected. So I don't really mind whatever you ask other landlords. I'm not concerned with that. I'm more concerned with what comes out of your own mouth. Okay. Could you ask somebody else? Yeah, you could ask. They're probably not going to tell you. And if they do, that's their problem, not your problem. Okay. Where I'm concerned with is what comes out of your mouth when someone's inquiring from you. So I would zip it. Don't say anything. I'm sorry, I don't discuss things that happen during a pandemic that affect our entire planet. There's other words, other verbiage you can use. Just don't do it, okay? It's gonna be expensive and it's gonna suck bad. So just don't do it. Simple. Okay, everybody got that on screening, please. I beg you, remember going forward, we're talking about 16 months that you can't disclose to anybody going forward, not to lenders that are inquiring if they want to purchase, not to anything. They were affected, they're protected. You keep quiet. That's the best thing you can do. I'm sorry we don't discuss things that happened during COVID. Do you have any other questions for me? I mean, it would be really simple, but you guys need to be adamant because if you mess up, that's going to cost you and it's not going to be cheap. Just saying. Okay. We can avoid that one by just being quiet. All right. Do we have some questions, Hootie?
I'm saving them till the end, please. Let's
Okay,
just
not a problem.
Finish the slides.
Hey, no worries. We'll do the slides. You lead, I follow. New requirements for small claims court and ordinary civil action seeking COVID-19 rental debt. Everybody sit down and buckle up because this one's going to be a little confusing, but just work with me, okay? If you have a tenant that vacates at any time from January 28th going forward, you cannot include rents owed on your disposition of security deposit unless the tenant signs and agrees to it. They have to sign stating you can take rent out of my deposit. If they don't, you can't charge rent in a disposition of security deposit. You have to send a demand letter starting August 1st on the money that's owed for the rent, and then you can start a small claims action on August 1st. Don't everybody run down to the courthouse on August 1st. It's going to inundate the system, okay? Remember, you're on an oral agreement. Your statute of limitations is 2 years. And on a written contract, your statute of limitations is 4 years. So you have up to 4 years to go sue them for the money they owed you during the COVID pandemic, okay? It's not something you need to run down to the courthouse and file for. You have time, okay? And the only reason I'm saying this is half the state of California is going to run down to the courthouse. Don't get lost in the masses and in the shuffle. Wait a bit, wait 2 months. It's not going to kill you to wait 2 months and then do it, okay? I'm just saying because that's how it's going to go. This COVID rental debt that we sue in small claims for is no longer considered rents. It's considered consumer debt. And they've also passed a provision in the consumer debt, don't shoot the messenger, that it is unassignable. What does that mean in simple English? It means you, the landlord, have to do the wage garnishment, the writ of execution. You have to find the money. You can't hire a collection agency or a law firm to do that for you. So I've had a talk with a couple of law firms and they've all decided they're going to be doing a lot of document prep work to help these landlords. Okay, so keep that in mind. Your legal firm and your collection agency is still going to be able to help you, but they're not going to be able to collect on the debt for you. That's something you're going to have to do. Okay. Youch. So the money that's owed during the pandemic, they owe 25% of the rents on or before June 30th, and the other 75% balance becomes consumer debt, and you can only sue in small claims and you cannot assign it. See how more and more that we talk about what we can't do and how we have to do it, it makes more sense to go after the 80% from the government. Because let's face it, If 75% of somebody's rent is in consumer debt in a small claims case, all that tenant has to do is file bankruptcy and they don't owe that money anymore. That 80% from the government's not sounding so bad after all, is it? Just saying. Okay. So you cannot file small claims until August. They're removing the cap amount to unlimited, so it doesn't stop at $10,000 because of COVID. Okay. If you're doing a disposition now, know that you cannot put rents in it that were owed during the COVID pandemic unless the tenant signs and agrees. Okay, next slide. Extensional limitations on local moratoria and on evictions. Okay, so for all of you that know that the County of Los Angeles has lost their mind, please take note. They have definitely lost their mind. Okay, I'm just saying. So LA County is one of the worst ones to try to do an eviction in right now. They've taken away some landlord provisions. California Civil Code 1954, you guys all know, is a notice to enter. So you want to go in the property to check, to show it to people that want to buy, to show it to lenders, whatever the reason you want to go in there. You could post a 24-hour notice to enter and gain access to your property. If your tenant refuses to allow entry under California Civil Code 1954, you can start an eviction against them for failing to allow entry, except in LA County during the pandemic. They are taking away some of our landlord rights, trying to help with the pandemic issue. Because LA was so heavily hit with the pandemic, because it's so densely populated, they have more restrictions and more rules to help with the COVID. So we're seeing a lot in LA County. I don't call it the justice system. I call it the just us system, because it seems like it's just us. They keep taking our rights away and things along those lines. They're making it extremely difficult for landlords. So in LA County is where we see the most of that. And that covers the entire county of Los Angeles, including parts of Wrightwood, Long Beach, you name it. Okay. So just know that LA, I call, is the devil's cauldron right now, because there's just so many things protecting the tenants in LA County that it just, I never thought in a million years that our government would be able to rewrite the terms of my written rental agreement telling me when my rent is due. That floored me. Okay. But then to be told that civil codes aren't enforceable, that just threw me for a bigger loop. And then I realized it's the devil's cauldron. Yeah. And I understand why they're doing it. They're trying to protect the mass amounts of residents in that area because they were so heavily affected by COVID. Okay, next slide. Yes, the CDC also extended the eviction moratorium to the end of March. So that's a federal order. The new president did that the very first day he took office, and my heart sunk. He sat there and signed all of those executive orders, and my heart sunk because I knew right in that moment that tenants watching go, oh, I can do whatever I want. You can't touch me, because some of them have that mentality, unfortunately. And it really made me very concerned, and I'll leave my statement at that. But the CDC did extend their no eviction moratorium on a federal level till the end of March. For those of you that are currently in eviction, what does that mean to you? Maybe your tenant didn't file an answer. Maybe they didn't do this. Maybe they didn't do that. As soon as they get posted with a lockout notice from the sheriff's office, they may go file an emergency hearing and just cry CDC's order. What does that do to our landlord waiting for lockout? It makes it so the lockout will not happen until after March 31st. So it extends the time that they have in the property, just so that you're aware. Okay, next slide. Okay, we're to questions and answers. Let me just review my notes really quickly while Hootie gathers up some of your questions so I can answer them, just to see if there was something else that I wanted to tell you guys. Talked about no rent increases. We talked about them being affected. 2 pages of retaliatory issues, no additional expenses to the tenant, no talking about what happened during the COVID pandemic, retaliation issues, my favorite words, if they're affected, they're protected, and they could be protected for up to 180 days after the pandemic. So that's 6 months. That's why I'm giving you guys the restart life as normal date as being January 1st of 2022. Okay, I am ready for some questions, Hootie.
Are you able to read that?
Yes. City of LA in 2020, HCI DLA approved our declaration for owner move-in. We placed our relocation fees in an escrow account. We had to cancel our 60-day notice in March 20th due to Garcetti's emergency order. Okay, before I read anything else, I gotta say, on a personal opinion, I think that Garcetti, the mayor of Los Angeles, Newsom, the governor of California, and most likely our new president should all hold targets at the local shooting range, because some of the things these guys come up with is ludicrous. Okay, let me keep reading. When we are ultimately allowed to serve our new 60-day notice, what happens if the tenant wants to refuse to leave in the owner move-in eviction? Do we still have to file a case in Superior Court to evict them? And how would that case proceed? Yes. For an owner to move into their own property, they lost those rights in LA County with Mayor Garcetti, along with the notice to enter and things of that nature. Again, I never ever thought that we'd see our government control us as much as they're controlling us right now. I am dumbfounded. I didn't realize that they had that much power over us. We're supposed to be free, right? Land of the free because of the brave. Yeah, I'm questioning that a bit. Most likely, once the pandemic's lifted, you're going to have a retaliatory period that if you terminate tenancy, it's going to be considered retaliation. So it may be in your best interest to wait until January 1st of 2022 to even serve the notice. And that's just me talking to you and trying to keep it as real as it is. Just because the retaliatory issues are so bad. I would definitely talk to your legal counsel about what you can do and when you can do it. But in my opinion, to be completely safe and avoid charges I don't want to pay for, I would definitely wait until January before I did any terminations of tenancy or any rent increases, not only for the legal aspect, but also for the ethic issue. Especially if you guys are licensed sales agents or brokers, you need to remember you are bound by your licensing to act in an ethical manner. So you want to make sure you're following good ethics throughout this as well. Can I initiate an eviction currently based on the cause other than COVID payment problems? The resident is a nuisance to our community in many ways. You want to talk to your legal counsel. If you've previously served a 15-day notice to pay rent or quit during the pandemic, and you now want to switch and evict based on a nuisance, my theory is then you better have a police report, code enforcement violation, or something from your municipality, meaning what governs us, okay? To avoid it being retaliation. If you previously served them at all for the money and now you switch and want to go after cause, that is most definitely considered retaliatory, and you'd be subject to fines and penalties by the court. Not to mention the tenant could file a lawsuit against you. So it may be a better practice for you to contact your legal counsel by all means, but having a police report, an incident number, an arrest made at the property, code enforcement violation, building and safety violations, they may be what you need for it not to be considered retaliatory. But again, please talk to your legal counsel. Everybody is in the same storm, but we're on different life rafts, remember? So it just depends on which way your boat's floating, for lack of a better way to explain it. The tenant applied for rental assistance. I haven't received it. Should I give a late rent notice? Absolutely. Serve that 15-day notice and make sure you do your disclosure. Rather than waiting for the tenant, which may not happen, whatever they applied for may be out of funds. I don't know. It makes more sense for you to cover your own asset and make sure you apply for that 80% through the federal government that's being administered through the state. Again, have your APN number handy. I don't know that you'll need it, but it makes sense to me. So definitely. What about cities like Santa Monica, which allow annual rent increases? The new moratorium trumps that, dear. So even though your city allows an annual rent increase, I would talk to your legal counsel before you administer any rent increase to a tenant during this pandemic, because the retaliation fines are atrocious. I get that your city may allow it, but you got to remember, your city, if it's more restrictive, would control. But if the government's rules more restrictive, it controls. And right now, from what I'm seeing in LA County, I don't want to poke that bear. Okay. Do landlords need to apply for the 80% for the tenants? Yes, absolutely. Basically, it bypasses the tenant entirely. It pays you, the landlord, 80%. You apply, and then you forgive the other 20%. You can never ask the tenant for that money. It is gone. The reality of that is, ask your local restaurant how much the government's helping them, because they're not. Okay. Okay, you guys are being given a golden ticket here, if you'll hear me. And I get it. We don't like the government. We don't want to participate in the government. Okay, let's talk about the alternative. The alternative is they owe you 25% of the rent on or before June 30th. So it's not even due yet. And then the balance becomes consumer debt that you can only sue in small claims court for, and it's unassignable. So you're going to have to learn to be a collection agent to go after that money. Simply said, what are the chances of us being successful on collecting that money? Simply said, makes more sense to turn and chase the government's carrot they're dangling, you guys. And remember, it's not a loan. Okay, it's a bailout. I don't want to call it free money, because all of us that pay taxes end up paying that money in some way, shape, or form, but it's not a loan. Okay. So landlords need to apply for the 80%. If you opt out of the program, the tenant can then apply for the 25%, just so you can't evict them. And then the other 75% balance would be deemed as consumer debt that you could sue for in small claims starting on August 1st. Can the property manager apply for the rent increase, or does it have to be the property owner? You can't do a rent increase right now. And I think you're talking about the money, the 80%. I would say that the owner would probably need to do that. They're probably going to ask some personal information, how title's held, etc. We won't know the answers to those questions until the 15th of March, when that program is launched on the website. Also, very key note and fact I need to add. If you are going to the website, housingiskey.com, and looking ahead of time, they have 3 or 4 notices on there for landlords that were administered by the Bureau of Real Estate. They are not valid in a California court of law. They do not comply with California civil procedure. They are up there for an example only. If you use the notices off of that website, how do I say this? The government is setting you up for failure. Those notices will not work in a court of law. If you read the disclaimer on them, they specifically tell you these might not work in California, and you need to contact legal counsel or an advocate group or an apartment association. So there's actually a disclaimer on the notices that are on that website. But I'm telling you, they're not compliant with California civil procedure. They will not stand up in a court of law in California. Don't use them. You're welcome. You're very, very welcome. You can serve a 15-day notice at any time during the month. You could serve a 15-day notice today if you wanted to for February's rent backwards through September. So September through February, you could serve a notice today if you wanted to. So it doesn't matter what day of the month you serve a 15-day notice, as long as the rent is delinquent when you served the notice. In other words, and I'm going to use January 1st as a great example, because the 1st of January is a holiday, so the rent isn't due yet. The 2nd of January was a Saturday. That's not a business day, so the rent's still not due yet. The 3rd was a Sunday, still not due yet. Rent physically became due on January the 4th, because that's the first day the bank is open, and came delinquent on the 5th. Okay, so very important that you guys understand that although the rent is due on the 1st, it can't come due on a holiday or a weekend. You have to wait for the first business day for it to be due, and then it's delinquent the following day. So for the month of January, you couldn't serve a notice to pay rent or quit until the 5th or later. Anything served prior to that would be a technicality that you'd lose on in an eviction matter. So very important that you guys understand that as well. Rent increase on tenants that have paid on time is allowed, correct? It is allowed, but it's not ethical. So if you're a real estate sales agent working under a broker, get it out of there. It's not ethical to raise the rent during an order from the government to shelter in place. It's unethical. It's a bad business practice. And later down the road, you're going to have to prove that tenant wasn't delinquent on the rent 5 years from now if they decide to bring up a lawsuit about something and include that time period. So it could be very challenging in the future. Can you increase rents if you're exempt from AB 1482, single family homes, not owner occupied? Or not owner, not a corporation. It doesn't have anything to do with whether or not you're subject to the statewide rent control initiative. It has to do with whether or not your tenant was affected by the pandemic. End of story. Okay, please understand that. It doesn't have to do with whether or not you have rent control. It has to do with whether or not the tenant was affected by the pandemic. And let me say this to you. We were all affected, each and every one of us in different ways. If our tenant didn't pay the rent, then we were affected by them being affected. If we had to go buy masks and hand sanitizer and had a shortage on toilet paper, we were affected. Affected is a very broad term that could be easily argued by opposing counsel in a lawsuit. Simply said. Everybody got that? Please understand that. I would not raise rents during the pandemic. I would reverse it, even if they paid me rent on time every time, because I'm going to have to explain that for as long as that tenant lives in that property going forward to everybody that questions it. Why even go there? It's not right. I'm not saying it's not illegal. It's just not right. Same example I used earlier with what if your mortgage company increased your mortgage payment and then told you you couldn't raise the tenant's rent to compensate it. That's not right. These people were told by the federal government to shelter in place. How are you raising their expenses? That's not right. Okay. Also, we have a state of emergency for those of you that are inquiring about increasing your rents, regardless of what I am trying to say to you. And if you're going to do it, you're going to do it. So please know that if you increase rents more than 10%, you are subject to criminal fines, 6 months of jail time, and it's not pretty. It would be price gouging during a state of emergency. It's California Civil Code 396, subparagraph B. That specifically states that a landlord cannot increase rents more than 10% during a state of emergency. Just so everybody understands, we've been in a state of emergency since March, and it is continued now until June 30th. So any rent increases over 10% could land you in jail. Hate to say that, but it's reality. So if you are going to increase rents, please make sure you do not do it over 10% over a 12-month period, because that one will get you in a carrot suit and fines start at $10,000. So give a 60, I think you mean a 60-day rent increase notice on 10/1. I wouldn't even serve the notice until the pandemic's over, because that could be considered retaliatory. I mean, think about it this way. If the tenant's in a lease, we can't serve them a notice during the lease. We have to wait for the lease to expire. Wait for the pandemic to expire. Protect yourself. Nobody wants to pay for a lawsuit. This is where all the lawsuits come from, you guys. Pay attention, okay? Whenever something like this happens, that's when we see a whole bunch of case law. That's when we see things heavily litigated because there is no case law. So that's where we don't want to have skin in the game. We want to err on the side of caution and let somebody else make the mistake of challenging that and writing that out through court, because the legal fees alone are going to be in the tens of thousands of dollars to defend you. Okay, we don't want that. That's expensive. So error on the side of caution is the best business practice. Wait until the pandemic's completely over with so they can't scream retaliation at you. It's not going to kill you to wait 2 more months to do that increase of less than 10%. Okay. Will I be able to apply for the rental assistance program if I have already received assistance from the LA County Authority totaling over $9,000? From what I understand, they will pay 80% of your loss of rents during the COVID pandemic. So you are applying that $9,000 to your ledger, however it was distributed. However, if there's still a balance due on your account, you can ask the federal government to pay 80% of that balance that's still due. I would apply for the money. The worst thing they're going to tell you is no. Okay. Does no fault also include landlord taking property off the rental market and listing it for sale? Absolutely. That would be a no fault. And right now in LA County, you can't do it. You can't move back into your own house, not in LA County. They are extremely restrictive. And please listen to me when you guys are thinking about raising rents and you're taking what I'm saying into account and how you're willing to risk it. You're in the devil's cauldron. No bullshit. They're taking away our rights. We, as a landlord, cannot enforce entry. In other words, if we want to list our house for sale and we post a 24-hour notice saying that we want to show it to prospective purchasers, they don't have to let us in, and there's nothing we can do about it. Can you hear me? They are extremely tenant protective right now. I wouldn't challenge that with a 10-foot pole. Okay. I don't want to be in litigation. I don't want to spend that expense unless I have to. So very, very important that you guys hear what I'm telling you is this is where the big lawsuits come out when something happens and a law changes. So we want to be very careful that we're not making ourselves subject to that kind of a lawsuit. Okay, especially one that's gonna write case law. Okay, let me see what our next question is. Somebody's trying to call me right now, so I apologize for the glitches. What about a maintenance charge, cleaning up a stoppage that was tenant neglect? I wouldn't put that on the ledger until the pandemic's over, and I'd take it out of their deposit when they vacated. But that's just me. They still owe that money, absolutely. But right now we can only have rents on our ledgers. So I would hold on to that invoice and I would apply that invoice to their account after the pandemic has been lifted. And that's just the way I would do it. Because yes, if they stopped up a toilet or they broke a window, they did that. That's on them. And they still owe you that money. But we can't ask for it during the COVID pandemic. That's fine. Put the invoice on the ledger after the pandemic's over. That's just my opinion. Okay. Can we pass on retrofitting costs if they've been approved by LARSO? If you got approved by the program to pass those costs through, then pass them through because you were approved by the entity that's telling you you can't do anything. Okay. After the eviction moratorium, can I increase the rent on one tenant? He was the pain in the ass, and not on my other tenant. He behaved with integrity. They both have similar 2-bedroom units. In the event that you do that, you're most likely making yourself subject to discrimination from the Department of Fair Housing. I'll give you an example. If you have an apartment community and one of the units faces the swimming pool and the other unit faces the trash dumpster, do they pay the same amount of rent? No. The person with the pool is most likely the view of the pool is most likely going to pay more than the person with the trash dumpster. If the person with the trash dumpster is a jerk and you keep increasing his rent and not the person with the pool, and now his rent is more money than the person that has the view of the pool, don't you think that fair housing is going to say that you're discriminating? You're going to have to be very careful that you guys aren't discriminating because of this. I get it. A lot of these tenants were not affected by this pandemic or were slightly affected by this pandemic, and they're just exercising their rights. With that being said, those types of humans are in our country. We can't get rid of them, okay? We can't penalize them. We can't, okay? Just err on the side of caution. Make sure you're treating everybody the same. Just because one guy's a jerk doesn't mean that you can come after that one person. You have to do right by everybody. Everybody has to be treated equally, even the jerks, okay? What can we do about lease renewals, especially if we don't want a tenant there? There is no non-renewal of lease right now. Thank you, COVID. Okay. So if you're saying, I don't want to renew and here's your non-renewal notice, you can't do that. It doesn't exist right now because of COVID. What you're going to have to do is let them carry over to a month to month. And then when we can terminate tenancy without cause again, which my guess is going to be January 1st of 2022, unless this gets extended, that would be the safest way to play. And on January 1st, then you could give them a 60-day with no reason unless this gets extended again. But at this point, your home free date is January 1st, 2022. That is your safe escape date, you guys, for right now, unless it gets extended again. Does LA County allow for appraisal if the tenant refuses setting up an appraisal date? No, that would be a 24-hour notice to enter. You can't enforce that in LA County right now because of COVID. It is no longer a cause for eviction in LA County. There's nothing you can do about it. I know, I'm sorry. It sucks, but now you know why I call it the devil's cauldron. I never, ever thought in a million years they would take away our rights as landlords to that extent, okay? So an owner moving back in can't do it right now in LA County. Makes it extremely difficult. Yeah, LA County's quite challenging, for lack of a better way to explain it. And the reality is, how much money do you guys want to spend to prove that you're right? Because that's what it's going to boil down to. Is it a violation of your civil rights? In my opinion, absolutely. But are you going to spend the money it's going to cost to litigate that and make case law from it? Because that's going to cost you tens of thousands of dollars just in legal expenses, not to mention what's going to happen to you if you lose. Youch. I don't want to play. I'd rather watch that show, not be a part of the cast. Okay. I may lost the info. I apologize. With the tenant that has not paid March 20 rent and has not paid the 25%, could you start eviction? That would depend. Remember, the March rent through August rent is considered consumer debt, and you can never evict for that rent. That you can only sue in small claims court, but not until August of 2020, August 1st. As far as the rest of it, if the tenant didn't return the declaration to you, you could start an eviction on non-payment of rent. Here's something that you guys all need to understand, and it may put in perspective why I call it the just us system rather than the justice system. Because right now it's just us, okay? Just so you guys fully understand what you're talking about, in LA County, an uncontested eviction, meaning that the tenant doesn't fight you at all. Uncontested. They don't show up, they don't fight you. Normal uncontested eviction in LA County is currently taking a minimum of 6 months. Okay, so if you start an eviction, you don't get any income during that eviction. Okay, remember that. They are taking 6 months uncontested. For all the laws that we see changing out here that are affecting us, please know that the Judicial Council is also changing their process and procedure in the courtrooms, in the courthouses. I'll give you an example. Notice of entry of default. That's when the tenant doesn't file an answer and everything goes smooth as pie. Currently, they are not allowing court clerks to enter defaults. Only a judge can do it. So all of the cases that need defaults entered go into the judge's chambers, and in between him hearing cases, he is approving notices of request for entry of default. That process went from taking 10 days to taking 6 weeks because the judges are doing it, okay? Evictions are taking longer. Half of the state of California is trying to do an eviction right now, okay? The courts are inundated. They're short-staffed because of COVID and they're inundated. I mean, it's no joke, you guys. You're looking at 6 months to do an uncontested case. If they fight you and it's contested, it could be anywhere from 8 months to a year is what we're seeing. Okay, so when you keep thinking of this justice system that we have, please understand right now it's compromised because of COVID. So what we used to do is being really quick and easy, uncontested 3 months and you get your property back, doesn't exist right now. Okay. Please ask your legal counsel, how long does it take to do an uncontested eviction, and see what they tell you, okay? It's taking more time than it should, okay? Should we remove RSO and SCEP fees from the ledger? Nope, you can keep your RSO and your SCEP fees on the ledger. Those aren't additional charges. They've always been on there. Fair enough? So you can't add anything new to the tenant. No late fees, no interest, no fines, no penalties. No, you have to get insurance now. You can't change what and add any additional expenses to the ledger throughout the pandemic. If it's always been that way, then it can stay there. If they've always paid their utilities that way, it can stay there, but you can't add anything new. What about all the fines imposed by the HOA on the properties where the tenants have been affected by COVID? Are the owner liable for those fines? Absolutely. The owner's absolutely liable for everything. You need to remember that, okay? The owner is the ultimate catch-all. Whether they leave and don't pay a water bill or they leave and don't pay HOA fees, those are always going to fall on the landlord. Okay. Why? Because the landlord is who they can go after and have some teeth there. Whereas a tenant, they may just be chasing their tail. So let me continue reading this. What about, or should the owner pay it and then leave the amount to reduce it from the security deposit at the end of the tenancy? Absolutely. That's probably the best business practice that we could have right now, is just remove it, add it to the ledger after the pandemic is gone, okay? That would be the safest way to deal with it. All right, we are going to end things for today. Thank you, big thank you to PRC for putting this together. You guys, PRC is the most awesome restoration company. They actually will answer their phone at 2 o'clock in the morning if a pipe breaks and a unit's flooded. They will come out at 2 o'clock in the morning and give you a free estimate and tell you exactly what's going on. They will talk to your insurance company directly so you don't say the wrong thing and get your claim denied. And to me, that is priceless. Okay. So just something to keep in play is PRC definitely knows what they're doing, and we enjoy being able to have them as part of our little tribe of cheerleaders that go to bat for us as homeowners, because we don't get that very often. And thank you for all that you do for not only me, but my clients. I appreciate you.
Thank you, Patty, for all the great information and everything that you taught us today, for joining us. I want to say thank you to everyone that joined us. Thank you, Sandra. I know Sandra talked about a little bit of our services at the beginning. I also want to mention, please take advantage of our free assessment. We are open 24/7. We have an on-call number that you can call and reach us at any time. So I just want to say, if you guys have any questions for us, we left our numbers on the comment section. Feel free to contact us. Go on PRC Restoration Inc. and get our number.
Well, thank you, everybody, and thank you, Patty, once again.
All right. Thank you, everybody. Stay warm. I know that sounds funny, but stay warm.
You too, Patty.
You